I'm Chad Main, the founder of legal services provider Percipient, and this is Technically Legal, a podcast about the impact of technology and innovation in the practice of law. Today's guest is Federal Magistrate Judge Tony Leung from the Minnesota District Court. He and I talk about some of the do's and don'ts of video for court hearings. He talks about where it's working, where it can be a little more difficult than in-person hearings, and why access to internet might also be an access to justice issue. If you've listened to a few of these podcasts, you know the show's angle is how technology can be used in legal and how it's impacting and innovating in the practice of law. We've had some great guests, people that have started software companies, lawyers from both in-house and law firms that are using tech and innovation to deliver value for their clients. And we've had other guests, other important members of the legal ecosystem, like analysts and project managers, who are also key to improving the delivery of legal services. In most of these episodes, it's often the case that the guest made a conscious decision to use technology or software in a legal practice, or they had a desire to innovate because they just knew there was a better way of getting something done. All of this stuff is super exciting, and I like to geek out on it. In fact, that's why I started this podcast. But, as evidenced by today's episode, sometimes the legal industry finally just catches up with tech. Or we figure out that as a matter of doing business with others, we need to work like they do and use the tools they do. Email comes to mind here. Even though many other businesses started using email as the preferred method of communications in the mid to late 90s, it took a couple of years for law to catch on. We were still enamored by fax machines and snail mail. In today's episode, we are talking about the use of video conferencing in courts with Magistrate Judge Tony Leung from the United States District Court for the District of Minnesota. Now, admittedly, the use of video conferencing technology for court hearings was expedited by necessity because of the pandemic. But at some point, I feel that legal would have gotten there and started using video more often. Video is a good example of technology that was being used often in other industries, but just wasn't too prevalent in legal. But now, because we have to, the legal industry is using it like everybody else. And sometimes people in the legal industry are actually seeing the value in video conferencing. Like email, I have a hunch for certain activities, video is here to stay. So, if it's going to stick around, who better to talk about it than a judge? So we can get some do's and don'ts and learn about the effectiveness of video in courts in general. Now, today's guest, as I mentioned, is Judge Tony Leung. He and I, of course, talked on Zoom about Zoom. That only makes sense, right? Judge Leung is a pretty impressive guy. He immigrated to the United States from Hong Kong at a very young age and went from valedictorian of his high school class to become the first Asian American judge in Minnesota at both the state and federal levels. You moved to the United States when you're 6 years old, initially here near Chicago, Aurora, but you end up in Minneapolis. What brought you and your family to the United States?
Well, at the time, it was 1966, and if you were up on, keeping eyes on the international news, China was a very different place back then from what it is today. China at that time was in the midst of a cultural revolution, which brought real chaos between very powerful segments of Chinese society, what I would call the traditional Maoists who wanted the traditional revolutionary ideals to be pursued in the way that they thought, versus what I would call more of the states, the government, and what I would call more the practical factions of the Chinese government. And really, it created chaos all over the country. And my parents, who left China after the communists took over, they immigrated to Hong Kong, but of course Hong Kong was was just a colony. So I always like to say I was born a citizen of nowhere, but a subject of the crown, which is something that's very important to me now that I conduct the naturalization ceremonies. Because in essence, one of the things we say is, you give up any loyalties to any crown or potentate and a bunch of other titles, that big words that I haven't heard of before. And, that is very meaningful. So they knew that if push came to shove, the British government wasn't going to go and stand in the way of China eventually. So my parents thought it would, in the long run, it would be much better for the kids to come over here. And so my father actually left Hong Kong when he was about 48 years old, gave up his tailoring business of Western suits, and came here and became a cook.
Oh, interesting. Interesting. So he did not keep pursuing the tailor?
No. Because when we came here, there was really no employment for my parents. And so we had a distant relative up in the Twin Cities in Minneapolis who was a head chef at a big Chinese restaurant there back then called the Nankin. And that relative got my dad a job up here. And so that's how we ended up in Minneapolis.
Just basically where you grew up, your formative years, school, high school, right?
Yeah, I'm a Minnesotan all the way through, except for college and law school, and some visits overseas, I guess.
And then college, speaking of which, you went to Yale for undergrad, is that right?
I did. I went to Yale undergrad and graduated in '82, and it was an excellent education and obviously life-changing experience for me.
Did I read this right? When you were at Yale, you were the co-captain or the captain of the Taekwondo club?
Yes, I was. And back then it was actually quite interesting. In your tournaments, it was it was full contact tournaments.
Oh, wow.
And the only rules were you couldn't strike below the waist. And also, they didn't want punches to the head. But if you wanted to kick someone in the head, you could. And the reason was they didn't want it to turn into a boxing match or something like that. And so, yeah, it was actually quite fun. And I spent a lot of hours in the gym back then.
Do you still do any Taekwondo?
I stretch a little bit, and that's about it. And my son actually does quite a bit, and he's at Yale too. And so he's on the taking Taekwondo. Well, he's not at school right now during COVID. He's taking a semester off, but he does it as well.
Do you ever let that fact slip in the middle of a discovery dispute between two lawyers that's getting on your last nerve that you know Taekwondo?
No, Chad, there's one thing I learned a long time ago. I am a classic Southern Chinese person. I am not like about to dunk a basketball anytime soon. My height is a real challenge. And so I've all along learned you always go with the person who's bigger, who's in shape, who knows what they're doing. So I try to avoid those as much as possible.
Fair enough. I just thought, hey, let it slip every once in a while, try to let them know that you've got that background. So after Yale, law school, NYU, right?
Yep, law school. And in law school, I really ended up, I was attracted to NYU and also other schools because by reputation, they were very progressive and so forth. It was interesting. Once I got to NYU, their tax program and what I call their business related, like corporate contracts programs were really, really strong. And so over time, actually, I developed a little more interest in that. And in fact, then when I graduated from law school, I joined a relatively big, well, actually one of the biggest firms here.
Which is it's now Faegre Drinker, right?
Yeah, now Faegre Drinker.
So you went straight from New York, NYU to Faegre. You went straight to BigLaw.
That's right. And then I actually was in technically, I was in the real estate department of Faegre, but I did basically all transactional work. Basically, if you want to buy or sell anything, I'll help you. And the only thing I don't do is securities-based acquisitions. And to the chagrin and fear of some of our fellow partners, sometimes I got dragged into some other areas like family law.
Oh, wow.
Which some of the other partners was, what are you doing?
You're just learning. It's curiosity. So how long were you at the firm then?
I was there about 8-9 years and became an equity partner there. And it was sort of a significant time right around the time I learned that if I applied for the bench, I'd be seriously considered.
Were you thinking about that? I mean, as you went to law school, as you're growing up, did you think, hey, one day I might want to become a judge?
Ironically, no. In fact, I didn't actually want to go to law school initially. I was going to do U.S. Sino relations, maybe work, State Department, Foreign Service type of work. But I spent a summer in 1981 that was really eye-opening. 1981 in China was very different. I was at Peking University. And after that summer there, while I loved the country and loved the people, I thought it would be very difficult to spend a career at that time working with heavy bureaucracy, and I just thought it'd be frustrating. I always joke that had I followed that career path, I would probably be a billionaire by now. Because obviously China has progressed in ways that are really sort of unimaginable if you had the experience of seeing what China was before.
Yeah, I'm sure. I'm sure. So you apply to become a judge. You become a judge. You were the first Asian American judge in Minnesota. Is that right? And at the federal level too in Minnesota. Is that right?
That's correct. That's correct. Yeah, I mean, that was actually one of the factors that went into my decision whether to, in essence, change careers. Even though it's all law related, it really is a change of career because, the path of a equity partner in a big law firm. I think now it's the largest law firm in Minnesota, and it's a big career change. And especially at that time when I had to make the decision, our firm were really the lead counsel in the Exxon Valdez case up in Alaska. And we had won the $1 billion damages award and a $4 billion punitive damage award. And so it really was a decision, I had to make that, okay, what's the place of money versus, pursuing something that you may not otherwise get a chance to pursue. And so I went with that.
And this is mid 90s. You're at state court?
Early 90s, 94. Yeah. So
when you took the bench at the state, were you doing civil and criminal, one or just the other? Or
in the state bench, it's a general jurisdiction trial judge. So literally it's everything. So we did anything from juvenile delinquency, which is basically minors committing crimes, or juvenile child protection, which is, as it sounds, basically people have kids but can't really raise them. And also we did mental health work. We did criminal matters. We did anything from traffic tickets to multiple murders. Civil cases, we did things from car accidents to mass tort, and some civil litigation that literally when you're, some involved, just immense issues. I remember one especially where our settlement conference, I couldn't, and in state court, we do our own settlement conferences. I remember there was one case where it was almost impossible to get a time that made sense for anybody because literally all the players were throughout the world. I mean, there were representatives on almost every continent, other than, I believe it was, other than Antarctica.
And this was before Zoom, so did people participate in person? They call in? Or?
Phone, conference call.
Yeah. Wow. So you're at state court for how many years?
17.
And then what was the impetus for you to jump to the federal bench?
Well, in state court, I was very fortunate. I thought I just did so many interesting cases over time. And as I just went through, it covered the gamut of all the disputes that human beings experience in life. And so after doing something for 17 years, I thought, it'd be sort of cool to do something else. And the federal courts were always fascinating to me. And frankly, I wasn't that familiar with the federal courts. But, over time, then I did put my name in, and I was fortunate enough to be selected by, the vote of the sitting district judges of our district. And that was in 2011.
You were in the real estate department of FEGRE. How much time did you really spend in court before you went to the judiciary?
I was afraid you'd ask that.
No, I'm just curious. It just came to me.
Just remember, before I answer that, I want you to remember, actually, I think I'm a pretty good judge. I mean, I don't think they'd put me on the federal bench if I totally screwed everything up. No, what happened was I had been in a courtroom for 15 minutes before I became a trial judge, sitting behind the bench doing jury trials.
But the fact that you were able to hear all those kinds of cases in your role as a state court judge, I mean, that's more experience than most attorneys are going to have as far as different rules, different types of questions of law. So,
well, the first time, I always kid around and say, well, it isn't that hard being a judge. It's like most of the time it's 50, you got a 50% chance anyways, sustained, overruled, grant, deny. And then if you know a little bit about the law, you should hit 75. And if you know a little bit more, you should hit 90s. And that sounds pretty good.
So what would you say are the biggest differences between being a state court judge and a federal court judge? What really made you say, wow, this is different when you got to the federal level?
The first thing I sense was, you just have to be very careful just at the very beginning. You always have to ask jurisdiction. Obviously we asked jurisdiction questions in state court, but because it was a generous jurisdiction court, we really didn't get into that many sticky wickets with respect to that. But in the federal courts, we have to be very careful about that. So, procedurally, that's one of the first things that come to mind. And also in terms of how to commence lawsuits in Minnesota, the state court has what we call these pocket service, where you don't actually have to file the lawsuit to get it going by service. And so that was a very different system of, when technically things get rolling in a case, And so I think that was another aspect of it. The fact of the duties of a magistrate judge, of course, are much more limited than a general jurisdiction trial judge in state court. For example, I cannot constitutionally do criminal trials, nor do criminal sentencings. But with consent and so forth, I can do, basically everything else, including civil jury trials. And so that is quite different from the broader jurisdiction of a trial judge in the state court side. I would also think, as a general matter, I think the cases in federal court have maybe a higher level of complexity. Whereas we did, I've had some very complex cases in the state court, but they were more few and far between, whereas in federal court, there's just a lot more heavy-duty cases that we got to deal with. So, yeah, I think those are some of the main differences that I see.
So we're here today to talk about Zoom and your experience with it since the outbreak of COVID. Are you handling all your hearings via Zoom? Are there any in-person hearings that you've had?
I basically have been functioning almost entirely virtually since March 16. The only exception to that has been some criminal cases where the defendant has not consented to a video hearing, in which case we get them done, but it's actually quite a procedure that we undergo. For example, we have to coordinate the transportation from the detention facility to the courthouse. You have to take this measures that are, COVID measures that are required in that. And remember, when we take them out of the detention facility, when they go back in, they have to quarantine too. And so that creates some real space issues and other challenges to both the marshals as well as the detention facilities. Then when they get here, of course, we have to have a very well-regulated courtroom proceeding where we have invested tremendously in plexiglass. I always say, if you would have invested in plexiglass, in virtual technology and masks and hand sanitizers, you would have made a mint. But there is quite a procedure. I mean, we in the courtroom, for example, we'll have gloves, we'll have coverings that are disposable for the mics that people use. We have hand sanitizer. We have wipes that after the hearing, counsel is responsible for wiping down their respective spaces, as am I and my staff, as after our hearings. And we have masks that are available as well in case people have forgotten them. So yeah, it's complicated, but it's been very well thought out, and I think it works quite well. Once I get into the courtroom, I encourage people to keep their masks on when they're in the courtroom still. And it's only when it's their turn to speak that I ask them to take off their mask, and then after they're done, put it on. And in the past, of course, our protocol here has been you go to the center podium to address the court. And so we found that we don't want to do that. And so we actually will just ask the lawyers to use the mics on the counsel table. And again, each of them has a disposable mic cover so that they can take that on and off.
You mentioned this is for the criminal stuff. So, and obviously this is not exact science. In a week, What's your caseload? Like how much is settlement conference? How much are motions? How much are other types of hearings?
Our district is very unique. Our magistrate judges focus a lot on settlement conferences. And I would say that I guess a rough split of work, and this isn't very scientific, but my sense is it's about like 20% criminal and 80% civil is my caseload. And of my civil caseload, I usually schedule at least 3 settlement conferences a week. But in reality, what happens when you schedule them, I schedule them well in advance. Many of them go away by themselves. It's just hard to tell exactly which ones. And so if one goes away, I'll, substitute another case for that if there's enough time. Most of my time is actually spent in settlement discussions. And I think our district, all of us are actually quite proficient at settling cases here.
But you do have a motion calendar too related to civil matters.
Oh, absolutely. Absolutely. The motion calendars, I could be mistaken, but I don't recall I haven't had one civil motion in person since, again, March 16. I think the key to those motions is that the lawyers really have to line up their exhibits in advance so that they can easily reference them. And same thing with the in-person criminal hearings. One of the keys is for the lawyers to identify in advance, pre-mark their exhibits, exchange them, or at least make them available so that we can show them to each other digitally in the courtroom when we're ready to go.
When we come back, Judge Leung talks about why the lack of internet for some adds to access to justice issues. He also talks about some best practices for video court hearings, including why it's a good thing to get out of bed before appearing in front of a judge.
This podcast is brought to you by Percipient, a legal services company powered by technology. Percipient helps legal teams tackle legal operations, electronic document review, and process automation. Percipient services include managed document review, subpoena compliance, cyber incident response, and also helps legal teams provide clients with process-driven legal support. To learn more, visit percipient.co. Percipient. Legal services powered by technology.
We'll get back to my conversation with the judge in just a second. But before that, as I always do, I want to encourage you to visit tlpodcast.com, where we have a dedicated page for every episode. It's got show notes, more information about the guests, and links to some of the stuff they talked about. You can also sign up for our email list there so you know when episodes come out. If you want to subscribe, you can find us on all major podcast platforms. And if you like us enough, I hope you give us a thumbs up there in the review section. Finally, if you want to get in touch with me, you can find me on LinkedIn or email me at cmain@percipient.co. That's CMAIN@percipient.co. Now let's get back to my conversation with Judge Leung. The vast majority of hearings have been via video conference. What has been the most surprising thing to you that's a positive? That, hey, I didn't expect this to work this well? What aspect?
I would say that what I'd call the insouciant ease that we transformed in-court hearings into virtual hearings and to keep the docket going, I think that has actually been one of the real pluses. I have to admit that before COVID-19 hit, I wasn't too inclined to learn too much about technology. I won't say I'm exactly the number one pick in our district for leading a tech committee, far from it. But I think I've got it down well enough that I can hold my own conducting virtual court. So that has been a very pleasant outcome. The other aspect of it is I think most lawyers and most participants are pretty comfortable with it too. And I believe we've had good results.
Do you think it's more efficient for many of the types of matters that come before you? Well, let's just talk settlement conference. Do you think it's more efficient from a settlement conference perspective to have people in the room or via video on the computer?
I think that depends on the type of case it is and the level of complexity and what is required for settlement. If it's a very complicated case with heavy documentation, I think that those will still, even after COVID, will still be in person. I'm thinking more and more that a lot of my settlement conferences after COVID will I may start doing a number of them virtually, especially the ones that, let's say, where the costs of travel and, counsel, clients, staying overnight and everything else. I don't want those artificial costs to drive, a settlement. I mean, obviously, as a practical matter, it often does, as you know. But, I think on a structural level, it's not good to have those types of side issues affect the analysis.
Did you do any video types of hearings or settlement conferences before this hit? And the reason I asked this question is when I was practicing, I was thought back in only one time I had a case in the Southern District of New York, and we had a couple of hearings via video, and it was for that reason. So we didn't have to travel because we were here in Chicago and opposing counsel in New York. And then I started to think, well, as a question for you, have you done video before this?
I had not done video before this, but I believe that we either have had in our district one or two initial appearance type of hearings in criminal matters. For example, our state is really big. To drive from one corner to the other is, 8 hours or something like that. It's a long ways. And so for those initial appearances, I believe that maybe some of my colleagues have done that virtually. But for me personally, I had not. But the closest I've come to that is I did do a hearing. It was a case on Okinawa, and it related to some, a criminal matter that was uniquely not under the military's jurisdiction. I won't get into too much detail, but it's under the Military Extraterritorial Jurisdiction Act, I believe is what it's called, or something similar to that. And for that, we had to set up a overseas audio conference appearance from Okinawa to Minnesota.
Do you think going to video, when we talked about efficiency, kind of a similar question, let's just talk about your motion calendar call. Do you feel like you're able to handle more motions now than you could have before?
I think those numbers are probably the same. I would think a lot of the motions, I could probably rule on a lot more motions than, I do if it were needed. But the real challenge on motions is, even though I know what the ruling is, it's writing it up afterwards. I have two clerks, and they're working very hard on a whole slew of different types of motions and reports and recommendations and so on and so forth. Social Security cases and the like. So a lot of the backlog is whenever we have to write like a formal order from a hearing, then it really slows down the process.
That makes sense. And that you've got to do that regardless.
Yeah. And so I think that as more of a factor in like how much we can schedule is virtual or in person. I think for the out of town hearings, obviously it's a lot easier, I think, for lawyers and parties.
And you mentioned this before, but I want to actually get into the details of it. How do you handle a document-intensive case? You mentioned the settlement conference, maybe it's a summary judgment motion. What do the lawyers have to do to make that work?
It sounds sort of silly, but indexing is very important, and exchanging documents is very important. And so, look, I don't expect everyone's going to agree on what's admissible or not, but at least they should have them available so that both sides can, react to it. So I think one is just, organizing in that way. The other helpful thing is if parties are willing to identify, be a little more specific on the issues they really want to focus on in their litigation. And so I think those two, they're really related to preparation. I think those factors really help a lot. Just the familiarity with the file. In some ways, because it's virtual, you have to be much more precise. You can't just flip through your box. You got to know this is where I hit the button and this page.
And how are you doing that? How are you sharing that? If I'm going to talk about Exhibit XYZ, is it shared ahead of time? Presume everybody's got a copy ahead of time. Do you say, look at Exhibit XYZ, or are you actually putting it on the screen?
Yeah, we share them in advance. In criminal cases, we staggered a little bit and, try to come to agreement on, a time for who releases what exhibits and so forth, and witness lists and so forth. But yeah, during the hearing, I actually, one of the bits of advice I wanted to share is when you're having a complicated, like a document-intensive or complicated hearing, just make sure you have a big enough screen so that you can actually still see parties and actually see the document. Because the reality is right now I'm on a laptop. It's probably 12 inches diagonally maybe. And, when people flash a document up there, and if I have half the screen is, on us, you can't really see it, and you start leaning into it and it looks really goofy. So believe it or not, having a big enough screen, making sure your audio quality, as we were prepping for this, was a good reminder actually that audio quality is very important, as is stability of the link, the Wi-Fi.
So if there's one thing that bothers you, or what's the con? What's the biggest con you see with having to do your job via video?
Let's just take settlement conferences. I have always believed that settlement conferences are a combination of art and science. And by that, I mean, obviously we can look at the science part as, people read all sorts of books, get into, the psychology of negotiations and, night baseball, day baseball, this and that and the other thing. We can get into that, Nash equilibriums, the ladders of preference, those are what I call the science of settlement. But a lot of it is art. And a lot of the art has to do with the interpersonal relationship and trust that is created between, let's say, a mediator and a party and the party's lawyers. I believe that the virtual setting does not put me in a position to be as effective from creating that level of trust that I think depends a lot on interpersonal EQ type of skills that are hard to convey in a digital setting.
I saw that quote in your law.com article, which I will put a link to on the episode page for this, but that's what you said. And I think your quote was, as far as being able to get information from an analytical perspective, from the IQ perspective, I think video is excellent. From the EQ, the emotional quotient perspective, there's probably something left to be desired.
Absolutely. And where that translates is that before there are a number of cases that you go in and say, boy, this is going to be a real reach to try to settle it today. And, at the end of the day, it's settled. I'm having fewer of those sort of surprise successes than I had before when I was live. I would say the ones that, you think are going to settle or should settle or probably going to settle, they're still settling, but it's those reach ones that are more difficult. I think I'm having more, trouble getting those done. Now they're still getting done. It's just at the end of the settlement conference might not get done. But you'd be surprised when we leave the seeds of thought in people, they'll get it done later. Because in the end, we only have about 4% in a high year, maybe 2% in some other years of cases that actually go to trial. So most of them go away.
You kind of already touched on this in the criminal aspect, but I read some articles about the cons, and they've guised this as, at some level, as a due process concern. But that's not what I'm asking the question. I'm not asking this question as a member of the Senate Judiciary Committee at a confirmation. I'm asking you as a judge there on the bench what you're trying to do to accommodate these quote unquote cons. Like, certain litigants may not have access to the internet. They may not have the tech sophistication. You mentioned the criminal, how you accommodate the criminal cases there, but what about if there's a civil litigant that maybe doesn't have the internet connection or text? What is the court doing to accommodate that?
Oh, that's a very real, scenario. Now, most of the time we've been able to accommodate. In fact, I think we've been able to accommodate. The closest I had was, it was an indigent person. It was a case of, of lower value, and the person didn't really have reliable Wi-Fi, which, sort of begs a question, given the future is digital, what place does Wi-Fi have in the context of what, is available to every citizen in this country? And so in that, there were some real concerns, but they did have a phone that had some Wi-Fi capability. And in the end, we also had the fallback option had they not been able to get that together, because I think they were their housing was very unstable. And at points in the litigation, I think they were actually in a homeless shelter. So there are some real questions as to whether they would be able to access Wi-Fi. They ended up being able to do that, but the fallback was we also had an attorney, and their attorney's office was big enough to accommodate their clients coming into the office, literally in a separate room, and then they could just use their Wi-Fi.
So both parties went to the attorney's office, both sides?
In that case, they ended up not needing to because the client's Wi-Fi ended up working. But the fallback was, they would be able to get to the lawyer's office and just do it there. Though I think the preference of both plaintiff lawyer and the plaintiff in that case was to do it, in separate locations if possible. But I think that's a very practical solution because, knock on wood, most people are going to be represented. And also for our criminal hearings, we have these rooms that are set up for audio and video. If push came to shove, because there aren't like a ton of cases where the civil litigants don't have access to Wi-Fi, we can use those criminal rooms that are set up for audio and visual to handle that.
And as I was reading these articles too, it seemed to me that some of the concerns, which not unfounded and not they're legitimate concerns, but it seems to me as soon as people are able to get back in the courtroom, they're going to go away. It's not going to be forever that lack of Wi-Fi is going to be a problem to getting your day in court.
Oh, absolutely. I mean, those issues will go away. I suppose there still could be some access issues, but those wouldn't be any different than existed pre-COVID. And in fact, I think the experience of COVID, if anything, will probably provide more opportunities to make justice and access to the courts a little easier. In other words, let's say COVID ends today, thank the heavens. I think the learning that we've had from this experience says, for people who don't have the ability to get to court, people disabled, what have you, to live very far away, this provides a lot of good opportunities and ideas for the future.
And that's a good segue to one of the questions I had. What do you see, and we'll just talk about you personally, how do you see the future use of video going forward once people can get back in the courtroom and get in front of you?
I intend to use virtual as much as I can. And it will be, hearings as well as for basic court functions. It'll be subject to what the district, if we have district-wide policies. But I support the idea of having more remote work so that, my staff, my clerks, my judicial assistant, that they can actually work from home on a number of days during the week. And, for those with kids, it's a good option to have. I know that there's a downside, of course, to doing virtual work at home when you have young kids, but it's nice to have that option. Let's say you have a sick child and you can't find daycare. I think this this digital experience is going to just open more opportunities for that type of flexibility.
I want to move on to some tips, things that you've seen and suggestions you'll give to litigants. But I forgot, we didn't mention one pro. The one positive we've failed to mention is you can wear shorts with the suit coat and the tie and still go to court.
Yes, it's as I said to you earlier in our communications as we were preparing for this podcast, that I changed out of my plaids, and I didn't realize, I'm going to be on video too. So I put on what I think is a relatively, formal bow tie and jacket.
You look great.
But I will not show you, but I will admit that I have my sweatpants on underneath.
As you should. But so that actually, though, wearing casual clothes is, I read an article in this early on, and I think it was a judge in Florida, it's a New York Times article saying, look, even though you're on video and you're not physically in the courtroom, you're still in court. So I think there was instances of people showing up without shirts on and stuff. So, obviously be respectable, wear good clothing when you're going to a court hearing. But what else? What is the number one, suggestion you have for attorneys and litigants preparing for a Zoom court hearing?
Just because you're doing virtually and you could be doing at home, remember exactly what you said, that this is federal court and that your focus should be on this hearing, this settlement conference, or whatever this meeting is that we have. And that should be your focus, just as if you had come to the courthouse. You can't go and, do a side errand or work on something else when you're not active on the screen. I would say I think people have to realize the focus on what the task is today, because I've found that when people don't do that, it's not as successful. For example, I can't tell, but I get a suspicion sometimes when I have people on a all-day settlement conference that I think they're too distracted on a couple of the occasions I notice. I think they've scheduled several other things to go on during the day. And that normally doesn't happen when you're in the courthouse and you're sitting in a conference room. I mean, you can still have access to Wi-Fi and stuff. It isn't the same that, you're just doing another project altogether at the same time.
You mentioned checking your tech ahead of time and the audio and the video. How often is it that the audio is bad, the video is bad? Is that a common theme? Or
no? I would say at the beginning it was very shaky, but the shakiness had more to do with the apps, what apps people were comfortable with. For example, immediately after COVID started and before our district went to Zoom government, I actually had a number of hearings and settlement conferences where I basically set up my own Skype. And, obviously we weren't going to, have the most sensitive issues raised in those, that setting. But, for purposes of what we're doing, I felt comfortable enough, as well as the litigants and their attorneys, to do Skype. So initially it was like just an uncertainty of what platform you would use, Zoom, Microsoft, some of the others. So I think that provided some uncertainty. I think the Wi-Fi, people were just not, checking their Wi-Fis. I don't know, but maybe people have upgraded the speed of their Wi-Fi. But I've been having fewer problems with that as a general matter. I think, the video and audio apps that we use is, again, very key, as I mentioned. And some law firms like their own conference setup. I get a little nervous of that because then if you're the other side, you have no idea what's in the background, who can listen to what, and what their that other law firm's capabilities are. And so that
what do you mean by that? You don't know what's going on?
Well, for example, if we're supposed to be in breakout rooms and I'm talking to plaintiffs confidentially, if we're using defendants' app set up from their office, the plaintiffs don't know what the technical abilities of that app is from the defendant's side and whether they have the ability to listen in. Now, I'd hope that people don't, but I always say we should have a system where it's verifiable, not just trust.
Have you had that argument? Has someone come to you and said, Judge, I don't want to have this hearing on video because I can't see the witness there and there could be some funny business going on? And if you've had that argument, what's the response? How do you prevent against the funny business?
The funny business, the most we can do is admonish. Obviously, there's a lot of downside if they get busted doing something like that. I mean, it's going to be, potential contempt, maybe even direct contempt. There could be a reference to the ethics board, the licensing board. There are many sanctions that might be available depending on the context of the situation. So there's a big downside that we can remind people of. I've had that concern mostly when people have been arguing about, do we want to go ahead with a key deposition or not? And for a long time, a lot of the litigants were hesitant to do video depositions of the key witnesses because there was a concern that in a virtual setting, when you're asking a question of the witness, that you don't know if that side's counsel is sort of hinting at answers.
The funny business.
Yeah, the funny business. So that is probably number one in a deposition. Number two would probably be when you don't have someone's sitting next to you, you feel a little more alone. I think that ability of a lawyer to reassure their clients that, hey, I got this, that is not there as much on a virtual setting. And I think that, that's an important element of the experience. I would think those two are, factors that go into it. But at the same time, can we prevent, that from happening? The sort of hinting at answers or even giving answers. I don't know how we're going to bust people doing that. All I can say is we admonish, and if we bust you doing it, man, you are in serious trouble.
Yeah, and look, let's face it. They're still kicking the client under the table. That exists in the real world when the video's not there. So it's, that's not that different.
Or can we take a break?
Exactly. There's a question pending. No. Back to tips. What else would you recommend?
The dry run is very important because no matter how well everything's set up, I think you have to have the dry run. I think lighting, I don't know how my lighting is right now.
Looks great.
Basically, I've got several lamps up there, and I found a lighting system. It's called AIXPI. It's a 10-inch ring light with a tripod and a stand, and it's got a phone holder, and it's fairly inexpensive. It was about like $26 or something like that. So on lighting, I think having that circular light in the background is actually really good, and also makes you not look sort of evil. If how if you have lights coming under you look like a Halloween character. Also, I think speaker. I found there's some really good speakers. Some of those speakers are pretty expensive though, so I actually like very much this. Forget what the name of a Sonoson headset that we're using. I think that's really nice. We were joking about clothing earlier. I think you'd have to dress appropriately. For example, I'm actually sitting in my dining room, but I think, because I'm doing this podcast, I thought, well, maybe I should be a little more formal.
Again, like I said, I'm not judging. You're the judge. That's your job. You look great.
Given that you're in a plaid shirt, I'll show you what my actual background is.
All right, let's see. Yeah, because it looks like the courtroom now. Oh, that still looks great, though. Actually, that leads me to another question. How often do you see backgrounds in the back of your mind going, whoa, why do they know what's behind them? Like, could there be improvement there? And if so, what do you suggest as far as that goes?
Yeah, I think one of the weird things is we have people walking around in the backgrounds a lot. And if you're in a hearing, it's court. Maybe people shouldn't be walking around in shorts and a T-shirt in the background. Yeah, I haven't had too many. Well, I'll share one situation. I was signing a warrant once, and the person swearing the warrant was lying on a bed.
Yeah, that was like that New York Times article I read. It was stuff like that. Yeah.
Oh, yeah, you can't do that. But that was very early on. I think people have actually really learned how to do it now. So I think those are very rare.
We'll add that to the list too of suggestions when you're going to court. Get out of bed. That would be a good one.
So yeah, I mean, shirt, tie, jacket, and I think obviously being a fairly not soundproof, but sound sensitive environment. So for example, that I don't know if it's apocryphal or now, a very important court hearing where you could hear a toilet flush in the background. I don't know if that's an apocryphal story or that's real.
I'm sure it's happened.
So yeah, check the link beforehand, before the app, and make sure you know the meeting passwords and numbers. I would say call your IS department, your technology people, and have them be available and on hand should there be a problem. I would say, again, going back to the exhibits, you got to really be even more on top of your file than you normally are so that you can go right to the document that you want. We talked about screens. Another aspect that's helpful in case you lose your Wi-Fi link, it's important for people to have phone numbers and other systems of communication. that I think is something that people should remember. So before all my hearings and conferences, settlement conferences, we'll get cell phone numbers from the lawyers, and then the lawyers are responsible for making sure that they can contact everyone on their side.
Great. Anything else to add to the list?
No, other than I'm going back to Wi-Fi as number one. I think without Wi-Fi, we cannot make real this concept of making access to justice real and fair and equal for everybody. And I think, in light of the tumultuous, situation in this country, I think the idea of like fair and equal access for everybody is vital. I think Wi-Fi is actually a very important element of that focus on equality for everybody.
And like you say, it's more evident now than it ever has been. So,
right.
Well, Judge, I appreciate your time. Thanks again.
Chad, thank you very much. And I'm honored to be on this podcast.
Well, that's another show in the books. We appreciate you listening. So if you want to subscribe, you can find us on most major podcast platforms. You can find us on Twitter and Instagram too. Until next time, this has been Technically Legal.